Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. That's all I'm going to tell you is be careful. If you have that kind of attitude and you go into it.
Attitude, Judge, is just, I understand, I messed up. It's no one's fault but mine. Y'all really treated me like I'm constantly getting in trouble for it. I'm not.
Criminal court, did you think this was going to be rainbows and gumdrops? No. We set the case for trial today. That's it. I'm not here to play games. Charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. Is this how you understand this agreement?
I'm sorry.
You have two agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record, they're going to see this. What do you think they're going to do if you smell like alcohol or dope? I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term, so you need to understand, if you don't understand what a firearm is or what a weapon is, you need to talk to a lawyer because that's one of the conditions. Do you understand? When you pick up criminal cases, there are a lot of collateral consequences, as you now see. It can impact you in ways that you never, ever see. That's why you need to strive to never pick up any kind of cases. And when you pick up multiple successive cases, it kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. That's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. Do you understand? For you to complete this successfully, you have to do a Batters Intervention Prevention Program, what's called a BIP class. This is a 15-week, I'm sorry, it's 18, right? 18-week class that you have to go to one time a week for 8. You don't have to do this. You can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Attitude, Judge, is just, I understand, I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, it's just.
And here's the thing, though, Mr. Faris, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
It's a conversation.
No, but Nathan, I want him, how did we treat you in what way?
I mean, I'm not
Tell
saying
me.
y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20. I made a mistake. I was drinking. It was just a mistake.
Please do not admit to committing the offenses. We actually haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say you didn't commit a crime,
No,
then you're not pleading
this
guilty.
isn't like, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it. You know,
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
well, hold on a second. How old is the case? I mean, the case is from 20, it's 510 days old? No. We set the case for trial today. That's it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand, the way I talk to you now is in hopes that you don't pick anything up in the future, because
I haven't.
you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm sure you do. But I'm the one that I am one of those persons that means it when he says it.
I'm gonna hit the pause button.
You pick up a case in 2020, and now you pick up a case in 2023.
I'm gonna hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you. But what you're pleading guilty to carries with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in kind. If you plead guilty to DWI today and get convicted, which is what you're planning on doing, the second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away, and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well?
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we...
I'll just set it today because it'll be long enough that we can have a conversation.
That he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop.
I'm sorry, pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on him. Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely fail to stop at a red signal light. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID, and that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Hendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024 did then and there unlawfully while in the course of committing a theft of property owned by yada 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 with intent to obtain and maintain control, intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle the day after our two cases. How? Oh, I guess that's how they caught up to him, right?
They must have him, they found him, and that's when they arrested him on that, and then got picked up on me, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he?
Yes, Judge. It says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to speak with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high, I'm going to set them at $20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
Thank you, Judge.
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but and I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond with Felicia, and then after that, it's pretty good.
Thank you.
Okay.
Wait, excuse?
Yes, ma'am.
Thank you.
And thank you for everything.